Dropping back in, what we're talking about here are some of the opportunities for citizen science engagement in federal environmental laws, because this gives a sense of the stakes for citizen science that has led to some of these First Amendment issues arising. So in the regulatory bucket along this spectrum of uses, you have the Administrative Procedure Act, which lays out the federal rulemaking process. Similarly, it's going to have notice and comment, another opportunity for citizen science to be entered into. But I want to highlight that some of the federal environmental laws have petition processes where you can use citizen science as evidence in support of a petition where you're asking the government to do something. The Clean Air Act, for instance, has a petition process to list different pollutants. The most famous example of that is the case Massachusetts v. EPA, where the Supreme Court held that the Clean Air Act covers greenhouse gases. That all started with an organization petitioning to list carbon dioxide as a pollutant under a certain Clean Air Act provision. And that's an opportunity, again, to use citizen science in support of your petition. The Endangered Species Act also has a petition process to list an at-risk species as threatened or endangered, thereby bringing it into the law's protections. And we've seen examples of citizen science be used on those petitions with birds who have several long-running citizen science projects, as well as with other pollinators. We've recently seen some examples with bees, where petitions have used citizen science in support of the argument to list a species and get it that protection. And on the farthest end of the spectrum is enforcement. And this is particularly important in an era where EPA's enforcement budget and number of enforcement actions have decreased. Some of the environmental laws, the ones you see here, have citizen suit provisions that allow interested organizations or individuals to bring civil enforcement actions, to bring lawsuits if someone is violating those laws, if they're operating without a permit and polluting, if they're exceeding the terms of the permit, or if they're violating the Endangered Species Act. And you can use citizen science as evidence in these cases. And I'd like to give a current example. In March, the Charleston Waterkeeper Group brought a Clean Water Act citizen suit over plastic pellet pollution in Charleston Harbor in South Carolina. You see a picture here from the local newspaper of a member of that organization collecting data, doing citizen science. And then here I have an excerpt of the lawsuit bringing that claim, where they talked about their citizen science protocol that they used. And that's the evidence of this plastic pollution. That is the evidence of why this polluter has violated the Clean Water Act. This is going to be a really interesting case to watch unfold. They're being represented by the Southern Environmental Law Center in it. But the citizen science is really the core evidence in this case of plastic pollution in Charleston Harbor. So with those uses of citizen science in mind as the stakes and how citizen science interacts with environmental law, there's obviously been a pushback by regulated industries against this use of citizen science. And the result, as Shaun mentioned earlier, is that many states have enacted restrictions on citizen science. And I'd like to give a very brief overview of those. So we see them in a few different categories of types of laws restricting citizen science. There's ag-gag laws, which Professor Marceau will talk about in a moment. The data trespass law, which Professor Pidot will talk about the Wyoming case. But I also wanted to flag two other types. There have been drone laws, which we've seen a significant increase of this spring during the coronavirus, as drones have been used more for news gathering and other activities. Some of these laws restrict the use of drones for certain purposes that could be related to citizen science. And then also species data laws. There's one in Texas and a new one that was passed in Arizona this spring that would make data collected about species, at-risk species on private lands, secret or confidential. So it couldn't be published or shared with the federal agencies that make endangered species listing decisions. So this is really cutting off the opportunity to use citizen science in endangered species listing petitions, something that we've already seen done. And these four categories of laws work in several fairly common ways. And four of the provisions, this is not an exhaustive list, but four provisions that have been important to courts are these types of restrictions. The first is on misrepresentations or falsehoods. So this is lying in order to gain access a lot of the time. This is really common in the ag-gag law context. The second is trespass, which obviously is key in the data trespass context, but all four of these will involve some aspect of trespass potentially. And we're talking here about having significant higher penalties for trespass rather than a typical state trespass law that's on the books, trespass related to data collection. The third is the method of data collection or recording. Is this a restriction on taking photographs? Is this a restriction on taking video? Is this a restriction on certain types of data collection? And then the fourth is once you've gathered that information, restrictions on the use of that data. Some of these laws place restrictions on publication or on submitting that data to agencies. So these are the restrictions that have been placed on citizen science because of that power and how it can be used in environmental law. Now, there's obviously then going to be the pushback to this pushback, and that's going to be First Amendment claims that have been brought by environmental organizations, animal protection groups, and press freedom organizations, challenging these types of restrictions under the First Amendment. So the First Amendment, of course, is going to have some of our most important constitutional freedoms. As Shaun mentioned, the freedom of speech is going to be the most important one in the citizen science context. I'm going to talk a bit more about that in a moment, but I also want to highlight the right to petition. This may not be the First Amendment right that comes to your mind. It's less well known. There's less case law. There's less precedent on this subject. But because these laws involve petitions to the government to get actions or petitions through the legal process in citizen suits, these laws also potentially implicate the right to petition. This provides an alternative means to challenge those laws, as well as bolsters any free speech claims. So why are we talking about speech, though, with data collection? I think it's helpful because it isn't intuitive if you don't think about First Amendment law all the time as to why collecting information might implicate speech. And the reason is that the Supreme Court thinks of free speech as a process with multiple steps. And data collection, which you often have in citizen science, could be at the first part of that process. And the First Amendment applies throughout all three of these steps. So starting with creating speech. Traditionally, that's going to be writing something down, taking your notes in a notebook as a reporter, something along those lines. This is really where a lot of these laws are going to interact with the First Amendment. They're doing the data collection to create speech later on. And in particular, speech related to these federal laws that can have citizen science play a role. The next step is distributing. This would be publishing that information, a picture in a newspaper, giving a speech, or including it in that petition, including it in that lawsuit that you're filing. And the third is going to be consuming, the person listening to the speech, reading a lobbying pamphlet, or reading that petition that's been submitted to a federal agency. The First Amendment applies throughout this entire process. And we have here a quote from one of the most powerful Supreme Court decisions about creating speech. This case was actually about data mining for big pharmaceutical companies. But the Supreme Court took a stance about facts being a part of the creation of that speech that's really important. And the facts that we're getting are the ones in citizen science data collection, evidence of pollution, evidence of species decline, all the things that y'all are talking about in this working group. So since citizen science does implicate speech in the First Amendment, the next question is, do each of these individual restrictions stand or fall as constitutional? And the way the courts go about this is they'll apply a certain First Amendment test or doctrine. The one that's been most important in the citizen science context has been content-based restrictions and the doctrine around that. So the first question we've already answered, is citizen science speech? There's a very strong argument that it is, in particular, especially with the creation of speech. The next question is, looking at these laws that have been enacted by state governments, are they content-based? And so one way to think about this is, do you have to look at the content of the information of the speech to decide if the law applies or not? For instance, it could be applying to a specific type of facility. So if it's a photograph of an agricultural facility, it falls under the law. If it's a picture of a minor league baseball stadium, it doesn't. So you have to actually look at the content of the picture. Is this an ag facility or is this a ballpark to decide if the law applies or not? That's content-based. We also see that in the Wyoming example with the definition of resource data. That is data related to land or land use. You have to look at the data. Is it resource data or is it something like, a pitcher's ERA? That's going to be data as well, but it's not going to be resource data. You can tell that I miss baseball right now. So you have this is going to be, is it content-based or not? Once it is, that gives you the test to apply. And here it's strict scrutiny. As you can tell by the name, that's going to be a tough hurdle to clear. The Supreme Court has said restrictions on speech that are content-based are presumptively unconstitutional. So there's a thumb on the scale against them. And the state would have to prove two things, that the restriction is narrowly tailored and that it serves compelling state interests. For the compelling state interest, they're going to point to promoting agriculture, protecting private property rights, or protecting privacy. Whether or not those are compelling is going to be an argument that you're going to be needing to make in a court case for each one of these laws if you're challenging it. As far as it being narrowly tailored, another way to think about that is there a less restrictive means to accomplish the same interest? That could be a content neutral law. We mentioned those standard trespass laws. It could be a subsidy. There are billions of dollars every year in ag subsidies, or another type of privacy law. If you can prove that there are less restrictive means in the strict scrutiny test, then those restrictions are going to fall. And this is going to be really the means by which these statutes are challenged. And that's the way to protect the use of citizen science for those federal laws, for those management and planning laws, for the regulatory process, in particular, thinking about petitions for species listing or pollutants, and then also for enforcement, thinking about citizen suits. And now we're going to turn it over to Professor Pidot, who will be talking about the data trespass example in Wyoming. Justin?
Sorry, I was going to unmute myself, and just then the screen shifted underneath me. Great, Frank. Thanks for giving us that sort of terrific overview of some of the issues. I thought I might start by talking a bit about the regulatory complexity that undergirded the Wyoming litigation that I was involved in, and indeed Justin Marceau was co-counsel on that case, and so you have some portion of the litigating team here. Frank did a nice job sort of explaining various buckets that we might think of citizen science as fitting within in the regulatory space, but often, and I think the Wyoming litigation is a good example of this, there may be other opportunities for citizen science to have regulatory consequences when either through a statutory mandate or otherwise, agencies are making decisions and accepting public comments. And so in Wyoming, as in all states, there's an obligation on the part of states to assess water quality within all of the water bodies within the states. This is required under the Clean Water Act. A report is put together. It's submitted to EPA. There are a variety of consequences, some serious, some pretty not serious, from finding that a water doesn't meet water quality standards. There's an organization called Western Watersheds Project, which generally is opposed to grazing on public lands, was looking for some legal tool to get at concerns they had about the degradation of public lands from overgrazing. And this water quality standards program was one of the ones that they settled upon. And so they have a staff member, a guy named Jonathan Ratner, who would go out to streams and other waterways on lands owned by the federal government where there was grazing going on under a grazing permit. And they would take water samples to see whether the water bodies were in compliance with water quality standards. And probably to no surprise, they found that there were pretty significant pollution problems in these streams, primarily from E. coli, because cows are hanging out in streams and pooping in streams, and the water quality standards are designed to be protective of public health. So they were uncovering data that indicated that these various streams in Wyoming exceeded federal water quality standards, should be on this list, and then they hoped that they could use these of water quality standards to try to restrict the amount of grazing that was being authorized. The ranching community did not view this effort favorably, I think one could say. The first iteration of litigation that Justin and I were involved in, a bunch of ranchers sued Western Watersheds Project for common law trespass because the way that land is distributed in Wyoming, a lot of the roads that the federal government builds that access public lands also cut across the corner of these private inholdings. And so ranchers' theory was, you're driving on this road crosses the corner of my property, I never gave you permission, you're trespassing in a common law, sort of a traditional common law sort of framework. So they brought this trespass claim against the organization. I think Justin had just gotten involved in ag litigation at the time. And so the executive director of the organization called him and said, can you help us? This trespass claim sort of seems a little bit like the ag stuff to me. The two of us then got involved defending the organization in that litigation. And I think pretty quickly it became apparent to the ranchers that this common law theory was not going to get them very much, because at the end of the day, they could not prove any damage to their property from someone in the organization, this guy Jonathan Ratner, driving in his truck along a road that was built by the federal government and maintained by the federal government. So their suit was not one that was going to get them more than $1 of nominal damages at the end of the day. So undeterred, they turned to the state legislature saying, can we come up with another way of punishing Western Watersheds Project for collecting this information about waterways, streams on public lands that are too polluted. And the Wyoming legislature came up with this data trespass law. And probably the most clever part of the data trespass law was that they called it a trespass law in hopes that that would sort of mask the intent of the law. But in its first iteration, what it did was prohibit the collection of resource data, which was broadly defined to include any information about the environment unless you were prospecting for oil and gas. So that was not resource data, but anything else was resource data. And the prohibition applied to all what they called open lands in Wyoming, which were defined as lands outside of towns and cities, so unincorporated portions of the state, including federal land, state land, private land, anywhere in the state, unless you had written permission from the underlying landowner. So we, on behalf of Western Watersheds Project and a number of other groups, brought a lawsuit challenging the constitutionality of that law. And the other thing I wanted to mention, so is the least clever thing that the Wyoming legislature did, is in their definition of what they were prohibiting. They included as an element of both the civil and criminal provision that you were collecting information for the purpose of submitting it to the government. As Frank said, very little case law about what the petitions clause means, but if it means anything, it would seem to mean that you can't punish someone specifically for providing information to the government. At least was our theory when we filed the lawsuit. We brought both First Amendment, both free speech and petitions clause claims, as well as some others. After the state filed a motion to dismiss, we prevailed before the district court. The district court said that he had grave constitutional concerns about the statute. Seemed like we were going to win, but the Wyoming legislature decided rather than give us a victory, they would amend the law. And they amended it in a way that that made the litigation more difficult. So they stripped out that provision about providing information to the government. They redefined trespassing to be only be crossing private land. So you had to actually be on private land at some point on your way to collect information from public lands. So there was this nexus with private lands that made it look a little more trespass-like. And indeed, the district court judge agreed. The district court judge dismissed our case when we amended the complaint. And he said, no, this is just about protecting property, a foundational component, a cornerstone of American democracy, the right to keep people off of your land, and that's all this is. We appealed to the 10th Circuit and prevailed in a very sort of wonderfully broad decision written by one of the more progressive members of the 10th Circuit bench. This is the Federal Court of Appeals that sits in Colorado, but also covers Wyoming. And the judge, I think the judges really looked to that language that Frank mentioned from the Sorrell case and other cases like that, saying that the creation of information does fall within the penumbra of the First Amendment. It wasn't obvious that that was true at the time. We certainly hoped it was true. We thought it was true. The Sorrell case certainly helped us argue that it was true. But I think there were questions about how broadly courts would be willing to construe the protection of free speech sort of upstream towards collecting information. And indeed, in the 10th Circuit opinion, in sort of gesturing at this difficulty, one of the prohibitions deals with the collection of material, like water, right? I mean, what was Western Watersheds Project doing? They were going and scooping up water. And our argument was that's speech, scooping up water. And the 10th Circuit says, we're not really sure that's speech. That's tough. It's hard to know whether collecting material itself counts as speech, but the law requires the law provides that collecting material only is prohibited if you record where you collected it from. And so the recording of geographical location information, the court says, clearly means that this is about speech. And so in the 10th Circuit's view, that's what sort of opened the door for our success. Now, maybe we would have succeeded otherwise, who knows? But the 10th Circuit didn't have to answer that question, which I think is a more difficult question about whether biological research that does not involve sort of traditional recording of information through pictures, videos, handwriting, whether that is speech. Is it speech when you go scoop water or take some dirt or have a device that's measuring pollution in the air? Again, I think that's, in some ways, that's sort of the next iteration of this litigation. If Wyoming has not amended their law again, but one could imagine a sort of data trespass 2.0 that was very specifically targeted at the collection of biological or environmental material without permission. And I'm not sure that we know the answer yet as to whether or not the First Amendment's protection would extend that far. I certainly hope that it would, but one never knows. And I suspect we will see something along those lines at some point. Probably not in Wyoming. Sort of the coda on this story is that that as we were prevailing in court on the data trespass law, the Wyoming Department of Environmental Quality simply rewrote their water quality standards to say that there were no E. coli standards for these small streams, so where they massively increased them. So rather than sort of making it illegal to collect the information, they simply made the information irrelevant, at least as far as the water quality standards program goes. So with that, I'll turn it over to the slightly lesser Justin to talk about his ag litigation.
Well, thank you. It's nice to join you all. I appreciated both what Frank said and Justin. I'm a bit of an interloper because I saw on Frank's first slide the guy wearing a citizen science hat, and I don't have a citizen scientist hat. I'm not steeped in this stuff, but I'm very grateful to be here and happy to stay in communication after the fact. As Shaun and others said, one of the things that I've worked on, both in terms of research and litigation, have been the ag cases. And I want to talk a little bit about those, but I wanted to sort of even take a step back first and just make a couple of mentions. One is, it's worth, I hadn't contemplated this before we started talking, but it's worth just noting among this group, which I know is a mix of many folks who aren't lawyers, that, at this particular time in history, among people left of center, it's not all that popular to take a strong position on free speech, I should just say. I mean, it's a bit passé, right? I mean, among my colleagues, if you take a strong position on free speech, it looks like you're sort of I could use various disparaging terms, but an American rights theorist, these sort of, and I don't want to go into that too much, other than just note, right? I mean, there's a bad side and a good side to speech, and the debate has some merit, right? There's a famous line of cases from the early 20th century about deregulation, and very famously Justice Kagan and Justice Breyer too, right? Justices who you might think would be on your side on these types of cases have talked about the First Amendment as a sort of deregulatory weapon, right? Justice Kagan famously described it a couple of years ago as the right having weaponized the First Amendment, right? So you see this in the popular press a lot. This notion that speech is out to get you, the free speech sort of champions. And I mean, you know, the questions that Justin ended with, I think, take you there part of the way, right? Where are the limits? And if collecting dirt might be speech, if collecting water is on its own speech, is dumping a little toxic waste in a river also speech, right? I mean, this is the critique from the sort of people who think that we've gone too far in the libertarian stream, right? So I just sort of put that out there to think about, happy to take questions about it. I myself think that these cases are really important, or I wouldn't be involved in them, but I do want to just give a nod to the fact that even the ag-gag litigation is certainly deregulatory, right? It is doing something that is contrary to the majoritarian or populist will, and that's exactly what's put the First Amendment in the crosshairs and some of these things, right? I also wanted to mention, when Justin sort of gave a great history of the Western watersheds and the Wyoming litigation. He didn't give the sort of postscript that I think is notable too, though, right? Because one of the reasons that I had agreed to get involved in this case is just, I always think, I've always been a fan of the underdog that's trying to do something good. And you had this lawyer in Wyoming that was representing the ranchers, and she was constantly going to the press and to us and saying things like, the only reason I'm bringing this case is to sort of put these citizen scientists out of business, right? I'm tired of them. They're a bunch of meddling fools, and if we can win this case, then maybe we'll take away their their nonprofit altogether. We're tired of them. Which seemed just kind of, well, it didn't seem funny, seemed annoying and kind of pernicious. But now, right, this woman was on the current administration's transition team, and I think has an appointed position with the Department of Interior, right?
Yeah,
so
she's in the solicitor's office.
Solicitor's office at the Department of Interior.
Parks, Wildlife.
So at the time, it seemed like this was kind of fringe litigation. Who would do this? Who would say these things? But now this person has a position of some stature. So. The other thing, where I wanted to go, though, from Frank's point was just I want to take one step backward. I think he did a great job of summarizing the areas where, through drones and all these different laws targeting citizen scientist actions. I would say you could even go take one other look at the way these things work and imagine that the transmission or the communication of the speech itself as being made more difficult by laws. And in particular, I would say, this president and existing laws about defamation, right? So the food libel laws and other things, these are laws that make it more likely that one will be liable, potentially criminally liable in some states, criminal defamation, for speaking against certain products that come into food. So you may say, well, does that really tie to citizen science? How could that come up? Well, the most striking example of that, and it was occurring to me, I was reminded of it when Frank was talking, is one of the largest defamation, so one of the largest civil lawsuits for saying something about another person or another industry was a 2017 settlement that ABC had for $180 million plus in a case where they described, I think the term they were supposed to use, or the industry wanted them to use, finely textured lean ground beef as pink slime. And you may recall that case, right? There was this sort of lots of media coverage of something called pink slime. But what you might not remember is that ABC didn't make up the term. It was a biologist, right? It was a biologist for the USDA. And a biologist for the USDA had gone in and said, well, there's some stuff and it looks kind of nasty. I don't know if it's dangerous or not dangerous, but the way that they make it, it's really kind of weird that they call it meat because they use this high-speed centrifuge machine with ammonia, and it pulls muscle and things off, and it's like really the after product of the after product, and then we can go sell it for hamburger. And this biologist came out with it, and then the national media ran with the story, and then demand for pink slime dropped, and they were sued in state court in South Dakota, right? And so the only piece that I'm adding to what Frank said is these aren't federal laws where you then go to a federal judge like Justin did and I did in Wyoming, or that we do with the ag laws. It's very hard to get these cases of sort of state tort into federal court. And so when an organization disclosing anything privileged, this is sort of common knowledge at this point, but I had talked a bit to ABC's lawyers. When you're an ABC or you're a big national media player covering citizen science, and you're in South Dakota or some other jurisdiction, and the judge says, no, we're going to trial. We're going to go to trial, and here's your jury of South Dakota citizens. You don't have recourse to a federal judge that might have somewhat more independence. The threat of liability is really high, right? ABC could have, been game over for them. Instead, they paid revenues that exceeded 1 year's worth of advertising revenue, right? So massive, massive liability just for talking about something that a scientist came to them with. So that brings me to the ag law, right? If the food libel laws are about limiting what you talk about or trying to chill the speaking, the ag laws are very deliberate efforts to control the flow of information to media and others, right? Citizen journalists and the like. And I'll just touch on a few of them. I mean, Frank talked about what they do, but the form, it really is what Frank said, right? So the two main templates are limitations on deception, limitations on recording, and then there's another model that's sort of you have to report anything you find within a certain period of time. So the deception takes a couple different forms. In Idaho law that we struck down in the Ninth Circuit, prohibited misrepresentations in gaining access and then misrepresentations in gaining employment. So anything that one said that they wanted to do in order to gain access to an area, and just this week, actually, the Ontario legislature in Canada debated, and it looks like they'll pass an American version of the ag law. It's exactly that. They've called it trespass. So they picked up on what Justin said is clever. They like that part. They called it trespass, but now trespass would cover anything. Only in an agricultural facility, consent is vitiated. Consent is not is invalid if the consent is secured through any sort of deception, right? So are you here to gather water quality samples? Are you interested in any of our pollution practices? Are you an environmentalist? Are you an animal rights person? You answer no to any of those questions, and then you come on the property, suddenly you are a criminal, right? So Ontario is explicitly invoking the need that American industries have expressed, even in states where their laws have been struck down. It's sort of spreading around. Same is true in Alberta. But in the US, the experience was that around 2012, states started doing this. And Idaho had a misrepresentation provision like that. We were successful in striking it down in Idaho in large measure. We can talk in more detail if people want to. Another form of prohibition is the ban or a limit on recording. So imagine that an employee wanted to record someone's unseemly practices for either depopulating their herd of animals or controlling their waste ponds, right? And their ponds are seeping into a waterway. They want to take pictures of it. They want to take a video of that. These laws were designed facially to criminalize all of that conduct. So, I mean, there's some misunderstanding about how broad they were. It wasn't somebody that was off the property. It wasn't the neighbor filming, but that's what those did. And I'll just say that they were pretty overt, they being the legislature, they're pretty overt in saying what they were trying to do here, right? So in Idaho, for example, sorry, my daughter has risen behind me, but the Idaho state legislature said things like, we don't want industry to be tried in the court of public opinion, right? So there was this idea of we need to avoid subjecting our industry to kind of media accounting. So it's pretty overt. Iowa is an interesting test case, and it goes a long ways towards giving us a chance to experiment with what Justin was just talking about. Because in Iowa, what happened is that in 2000, they were actually the first state to pass an ag law in 2012. They did so. There's a prohibition on misrepresentations, just like I described. That law was struck down, I think when the summary judgment was. The summary judgment was, I think, in 2017, late 2017. So we have a law struck down. In the interim period before, while it's up on appeal to the Eighth Circuit, and it's still on appeal, I should say, the Eighth Circuit probably wants to consolidate those. Is the only thing I can explain for why they've taken so long. But the Iowa legislature passed a new version of the law, substantially similar. So they appealed the version they lost on, and then they passed a new one. The new version was enjoined. It was a preliminary injunction, although summary judgment motions are passed, and the judge, much like Justin said in the Wyoming case, said he didn't have any patience for this law. So we're expecting it to be struck down. Iowa just this week, so excuse me, last Friday passed a third version. So they're on their third version, and the third version looks much more like what Justin described, right? If they're trying to extrapolate out, they said, and the governor signed it on Friday, excuse me. What they said essentially is, if you are on a property and you're doing any sort of collection or doing anything while trespassing, right? So it's targeting the investigations. I don't know if any of you saw this. Pulitzer Prize winner Glenn Greenwald wrote about it a couple weeks ago, the depopulating method, right? So this came about because I think he's actually a state senator, but one of the legislators in Iowa was subjected to an investigation by a group that did trespass, right? They were engaged in civil disobedience to get us information how a large farm was depopulating, terrible euphemism, their pigs, and they found out that what they were doing is closing off all the doors and windows and vents and turning up the heat as high as they could, and to see how long it would take to kill them. But it was taking too long, so they started piping steam in, right? So it was essentially trying to cook to get to death these animals. They didn't know how to do it. They didn't know how long it would take, but an investigator had video of them all doing this. And so the senator took to the floor and said, well, we just can't allow this, right? We can't have these citizens going out there and engaging in vigilante exposés. I mean, he used a phrase very much like that on the Senate floor just last week. So, I mean, this raises some of the questions that Justin said, right? Is any time somebody is gathering something, is it speech? If they pass a law that criminalizes, sort of aggravates the penalties for trespass in certain industries, is that itself speech violation? And where do the sort of property rights start or begin? But I will end there for now. Thanks very much.
All right, well, thank you very much to all of our speakers. I'm going to open it up for questions now. I did see that we did have one question in the chat from Ethan, which is asking about the relationship between the First Amendment doctrine we're talking about now and the Citizens United case, which was a First Amendment case about campaign finance spending. And I guess sort of getting to the point that you raised, Justin Marceau, about people on the left perhaps being concerned about the First Amendment being taken too far. Ethan just raises the question of whether this kind of litigation that's being brought to challenge these laws on First Amendment grounds could, have the unfortunate consequence of strengthening Citizens United.
Yeah, I think that. I mean, I think that's probably it certainly reinforces some of the reasoning, right? A case that preceded Citizens United called Buckley versus Vallejo. I mean, Buckley, it's fundamentally about whether things other than the spoken or written word are speech, right? Like Shaun said. So we actually cite Citizens United in our briefs because in Citizens United, they say it can't be that you have to wait until you're airing a video before you get to call it speech. It must be that if you wanted to raise money for the video, that is also a form of speech. So I think that, yes, the problem is there. I mean, in my view, the U.S.'s campaign, it's not a great idea to analogize to the campaign laws in the U.S. because I don't teach election law, but it's such a broken and just hobbled system with money influence and other things that you really need to go to a constitutional amendment specific to that. And I would probably support that. I mean, there's scholarship talking about, in fact, Citizens United is good, and it's just sort of the boogeyman that the left loves to hate because it's the best way for us to organize our money, and the left can, this sort of thing. You can organize and pool resources in ways. But I do think that there is that problem. I think you're absolutely right that it tends to at least entrench, if not make it more difficult to criticize some of those cases.
Yeah, I think mostly agree, although I do think, I mean, part of our theory of the case, and I think Justin's theory of the case in the ag cases are, the First Amendment, if it's about something, should be about protecting unpopular political viewpoints. And that even though there's a lot of doctrinal baggage that gets in the muck, one of the ways that I think one reasonably distinguish Citizens United from some of our litigation is that in the Wyoming case, you have sort of majoritarians trying to suppress a contrary perspective, and at the same in this perspective that's not just about spending money, that is about actually producing politically relevant speech. Having said that, I mean, there is certainly a risk that we all run of fetishizing the First Amendment. It's something that has happened in American law for a long time, and Citizens United is one great example. Hate speech is another example that certainly is on my mind in terms of how we think about so white supremacist speech and the extent to which we protect it in a variety of forums. I think that's a very challenging, difficult question that probably is much more directly implicated by litigation like the stuff that Justin has done and that I've done.
And Frank, did you want to speak to that question, or should we move on to the next?
I think just building on a little bit off what Justin just mentioned, which is that another area of First Amendment law that this can relate to is people recording the police and laws that have been passed in an effort to try to restrict people's right to record the police. So one thing to keep in mind when you're thinking about these First Amendment issues is that it's never going to be citizen science by itself. Each one of these decisions is going to implicate other parts of speech. And that's a double-edged situation, kind of like they're just both talking about. You can use sources that might not seem obvious to support your argument, but then there are also, you have to think about implications that are going to be broader than just the citizen science context.
And I guess along those lines of thinking about other kinds of laws that are implicated, I was wondering if any of you had thoughts about, trends in laws. So for example, are we likely to see anything like the Wyoming law in other states, or, thoughts about whether ag laws are moving in different directions and the implications of that. So for example, something like a North Carolina Property Protection Act, which is kind of neutral about the type of property it applies to rather than specific about agricultural facilities. And the third example to mention would be the pipeline protest, pipeline damage laws we're seeing now. And interested in getting your thoughts on whether those laws, raise the same issues, greater issues, maybe lesser concerns, or, how they relate to the laws that you've worked on more directly.
Yeah, I mean, I'm happy to answer quickly first. I'm sure the others have other thoughts. I mean, I think, this is a good example of litigation and advocacy working together. So in terms of the ag laws and the Wyoming law, I think that the sort of quick and effective and well-managed litigation has largely chilled the spread of these laws, at least initially. But they're still looking for other ways, right? And North Carolina is an example of that. You have the famous concurrence by Justice Jackson in an equal protection case, where he talks about the fact that equal protection is this great protector, as Pidot was just talking about, of making sure that the non-majority groups don't get pummeled by the majority, right? That it's a safeguard against that. And the way it does that is it makes sure that there's some bare level of equalizement, some equal protection of law. And he says, and when you try to screw everyone, I'm paraphrasing, of course, when you try to screw everyone, then the constituents are going to get mad at you. And North Carolina is a fascinating example where they said, well, we were afraid of just targeting, industrial production that is producing these environmental problems in the agricultural sphere. So we're going to apply it generally, and it's going to apply to nursing homes as well as daycares. And, you had the AARP and others coming out against it, but it still passed. The only thing I will say, so I think it's, legislatures are creative, and I guess, I think in this moment of hyper partisan politics and other things, it's very hard to predict what will succeed. And our structures aren't built for this, right? And I think that a generation ago, the justices couldn't have imagined a law like that passing. It seems to run counter to how we imagine legislatures would work. Having said that, I also think that the laws in North Carolina and also Arkansas are less of a threat, no threat, and I think they're unconstitutional, but the civil liability in those statutes is something that boards might be willing to take on. It's civil tort damages as opposed to criminal liability. So it is different in that regard.
Justin and Frank?
So I am thinking about the pipeline laws. I mean, I think one of the things that was easier about, I think, the ag litigation and the Wyoming litigation is that if you think about why someone is being punished, they're being punished because of some activity protected by the First Amendment, right? So if you had laws that say it's illegal to protest on pipelines, for example, would be subject to that same sort of analysis. I think it's, from a doctrinal perspective, it becomes much harder if you simply say trespassing on pipelines is subject to enhanced penalties, right? There are arguments one can make that the motivation behind the enhancement of punishment is aimed at chilling a particular kind of speech. But there are, sort of as Justin is alluding, I think there are ways that of punishing people for engaging in activity, if you're willing to sweep broadly enough, that probably don't fall within the First Amendment, and probably maybe even shouldn't fall within the First Amendment. I mean, at some point, there's space for democracy to decide the rules. Where exactly that is, I think we could all just debate. I'm not sure. In our brief in the Wyoming case, we said, look, if Wyoming's really worried about trespass, they can say 10 years of punishment for trespassing. Applies everywhere, applies equally. I'm actually think I am okay with that as a matter of the First Amendment. If you have generalized rules, even if they may be that in as applied, you can say you can find First Amendment problems, but I don't think the First Amendment should be used sort of as our hammer for every problem.
Makes sense.
I think that one thing that I would add is I've seen this spring there's been a big increase in state legislatures passing restrictions on drone use as a reaction to the coronavirus and people using drones for news gathering purposes and other things like that. There's a recent case filed in Texas about a Texas drone law there from the National Press Photographers Association. I think that we're going to see more things that look at specific technology that's being used and how, because technology has really spurred a lot of the growth in the use of citizen science. Everybody has a computer in their pocket now, and you can use that for much more information gathering. You use the internet to collect these massive data sets. I think that there might be people playing on privacy fears, as well as sort of growth of technology as a foundation for more laws potentially going forward.
Thank you. So I see we have a question in the chat from Marcia Scully asking about the significance of protections of corporate speech versus individual speech, and I'm thinking that, and you can speak, Marcia, if I'm not getting this correctly, but perhaps that the thinking behind that is that that would be a way of sort of cabining the impact of any of these cases on sort of Citizens United world, that if these cases are primarily about individual speech, then they might not necessarily strengthen that kind of precedent. But you could also speak if I'm not capturing your intent correctly. I've been not hearing. So is that a potential way of strength of these cases not not having the adverse impact of strengthening that perspective, that precedent based on that distinction?
I don't know. I'm interested in Justin's thoughts. I'm not sure that it is for the following reason. I mean, in the Wyoming case, for example, Western Watersheds Project organization was the primary target. To some extent, Jonathan Ratner, the individual, but Western Watersheds Project is a nonprofit corporation, but it still has its personhood is fictitious in the same way that corporations are. Now, there may be other ways of thinking about corporations, but I'm not sure that just trying to differentiate between corporations, if what we mean by that is environmental groups and others, that gets us where we need to go.
I see George, you're raising your hand.
Yeah, I just noted that in the chat, Luis has asked a question that kind of gets to a different legal question about citizen science, and it might actually be a topic for another entire program, which has to do with, at least I think where his question gets at, whether citizen science data will be taken seriously and treated as admissible in courts. I think that's what you're getting at, Luis. And his point is, we currently have human censors who see something and they go into court and they testify, I saw this thing, and then that's all accepted by the courts. And how is that different from a human using a device, going in and then reporting that? And I think I never thought about it that way, but that's a good question. It's a little different line of legal, little different legal issue than the one we've been focusing on here, but I know it's something you've thought a lot about, Shaun, and probably is an entire another program of its own.
I think that's right. And another sort of issue that Luis raised is whether the law, defines what citizen science is. And obviously in some contexts, there are legal definitions of citizen science, but I guess we should say that for all the things we've been talking about today, the laws we're talking about don't use the term citizen science. They don't say they're targeting citizen science specifically, but our interpretation of them and the potential application of them is that they would, they either are intended to apply to or have the potential to apply to activities that we would consider to be citizen science, which is why we're talking about them here today.
I think like
data trespass gets kind of close.
Yeah, that one seems pretty much directly aimed at. Yeah.
Two things I think might also be useful on this point. One is that in the example that I gave in the ongoing case in Charleston, they pointed to a specific data gathering protocol that had been peer reviewed. And so I think that if you're using citizen science in these legal contexts, it might be helpful to say, like, look, our members went out in the field and they collected the data, and here's how. And the way how is a process that's already been established and has already been peer reviewed in another context. That might be something that might be helpful. Another thing, looking at some of the Endangered Species Act petitions that have used citizen science, a lot of those citizen science initiatives were co-sponsored by the government. So for instance, the U.S. Geological Survey's Breeding Bird Study, which has been going on since the 60s, is a long-running citizen science program done with the government. And that has been a source of information in Endangered Species Act listing decisions. So perhaps when there's opportunities where it's not just an organization on their own, but a partnership with the government, that can bolster the citizen science in the eye of the agency or the court that is looking at it.
All right, Lee, I see you've raised your hand for a question.
Yeah, when I was at the Wilson Center, this would have been 2012, 2013, we had a lot of conversations with the EPA and the lawyers. And they were, at that point, now, things have improved since then, but at that point, very concerned about using citizen science data for their decision making, for concerns out of liability and congressional oversight. And so I had one of my grad students, who was a law student at the time, Bailey Smith, look at what the legal liability was. And so she dug up how citizen science was being used in the courts of law, and did not find at that point that the agency was being held liable for using what some consider to be, lesser quality kind of data, citizen data versus scientific data. So I think that's why EPA over time has moved towards improving their data quality standards for citizen science and issuing guidance on data quality standards, et cetera.
Let me just respond, maybe, Leah. I think there's sort of two separate questions, and one is whether courts will admit information that comes from citizen science in sort of as a matter of evidentiary rules. There's sort of a set of questions that one might ask. I don't try not to think about evidence. I have not tried not to think about evidence since I took it in law school, so I'm not sure I have a strong view of that. But much of the time what's happening is that agencies are making decisions about whether to base decisions on a body of information, and then their ultimate sort of agency action will be subject to judicial review, and they'll have to defend their decisions. So pretty favorable fora for agencies. I mean, agencies get a lot of discretion when it comes to making those sorts of decisions, but certainly there is some vulnerability that an agency, if you think about the Endangered Species Act, it requires agencies to make decisions based on the best available science. And you could see someone bringing a lawsuit saying, well, you relied on something that was not actually high quality science. You shouldn't have decided, maybe based your decision upon it. As a former DOJ lawyer, I feel pretty comfortable defending Fish and Wildlife Service most of the time in those cases, but but there are real questions that I think agencies need to address for themselves, irrespective of the potential for judicial review, about what kinds of information satisfy them, that it is sufficiently accurate, verifiable, to base some sort of regulatory action on.
I would just raise the point that I feel like there's a bit of a tension here potentially in advocacy on these issues. On the one hand, we're interested in promoting the use of citizen science by agencies, and despite, you know, potential argument that's not the best available science. On the other hand, we're also pushing back against actions coming out of the federal government right now that we see as imposing arbitrary restrictions on what kind of science they can use, such as EPA's so-called transparency rule proposal, under which they would not rely on scientific studies unless the raw data from those studies were made publicly available, which we just see as a sort of a ruse to exclude epidemiological data and other data based on, you know, confidential medical data from individuals. So there's definitely a tension there, you know, because obviously the agencies are going to get deference in court in terms of what they consider the best available science, and we want to expand their view of what's the best available science to include citizen science, but also want, you know, so in that context, we want them to be able to rely on more. And the other way, we don't want them to, we don't want deference towards their narrowing view of what kind of science they could consider. So anyway, it's something to be watching for as that rule potentially gets finalized.
One of the poster childs for citizen science that collects data to stand up in court is COAST, C-O-A-S-S-T, run by Julia Parrish. And she explicitly, when they set about starting their project and continuing to do it to very robust standards, with the intention that should there be an oil spill or some kind of disaster, that their data could be used to support litigation in a court of law as evidence. And perhaps that's something that this group could help to develop guidance for the community on how do you meet those standards for a court of law.
That's something to think about going forward. I see definitely, if that's something I'd like the group to be working. I see George mentioned something in the chat, which it gets to, you know, to the Wyoming law. We've been talking about the sort of the potential criminal or civil penalties for people who violated the Wyoming law. But another aspect of that law actually prevented, you know, the government from using data collected in violation of the law. And was wondering if I wanted to speak to sort of that aspect of it as being a sort of, you know, independently constitutionally problematic aspect of it.
Well, I'll give my view. I'd be interested in Justin's view. I think we probably talked about this at the very start of the litigation. I think that the claim is much weaker when what the government is doing is regulating the information that it will consider in a decision-making process. You have a right to provide information to the government. You don't necessarily have a right under the First Amendment, in my view, to have the government accept your information. Now, that doesn't mean that under the rules of the Administrative Procedure Act, under the underlying substantive statute, there might be legal claims that can arise. I don't think of them so much as First Amendment claims, at least not, they're not. There may be some circumstance, you could imagine a rule that said that when Justin Marceau submits information to the government, it will be immediately shredded. And maybe if there's sort of an outlying circumstance in which it becomes a petitions clause problem. But by and large, I think the government does all the time create rules about what information it will accept, what information it won't accept, and how it will process that information. And generally, that doesn't seem to me to be about to implicate the free speech of the individuals whose information is being neglected. Justin, am I wrong?
Yeah, I mean, you're certainly right that we argued about it. I remember that well. I mean, I don't know. I think it's hard. I mean, of course, Justin is right. I mean, that we do impose all of these limits, and they come up in different contexts. And I mean, I think I'm not sure that I ever had to fully resolve it, because the court kind of, I mean, there are parts of many of these decisions, if you go to read them, that are a little bit sloppy and different things. But setting that aside, I mean, you know, I do have concerns about the government sort of arbitrarily creating standards of what evidence is reliable or not based on who it comes from. You know, okay, it came from someone who is working for the following citizen science group. Can we prohibit them from petitioning? I mean, as Justin said, I mean, maybe that starts to look like a bill of attainder. Maybe that's some other sort of problem that's not a speech problem. Maybe you just win that fight in the you know, legislature. But I mean, it does raise concerns to me when you say, like, well, if they crossed any private property, no matter what they expose, then you can't use it. I mean, we don't impose those limits on the police, and for reasons that everyone understands, right? But yeah, I think it's a hard question.
And indeed, the ESA statutes that Frank mentioned sort of get at this, because those really are statutes, at least as I read them, about what information state agencies can provide to the federal government. And if the information comes from a certain, in a certain pathway, then it's deemed confidential and it cannot be disclosed to the federal government or to other state agencies. And indeed, Justin and I have talked a little bit about whether there's a First Amendment claim that can be brought there. And I am skeptical, although open-minded, and I will be especially open-minded if I ever bring that lawsuit. I will. So I don't want to be bound to a position today, but I think they are hard First Amendment claims to bring in my mind. I thought the Arizona's law was bad as a matter of policy. I tried to. I marshaled some Fish and Wildlife Service people to oppose it. I tried to get it defeated. It's a terrible law. I'm just not sure that it's not obviously a First Amendment problem.
Yeah, that's exactly the laws that I was about to mention. And looking at the legislative hearings in Arizona when they passed the law this spring, one of the people testifying in support of the bill said, the ESA is a really hard, difficult law to work with, and this is an attempt to soften it around the edges. And I think that brings in kind of a point here, which is that there's also a federal-state clash going on here, where a lot of the times these are states trying to limit the ability of the federal government to do something. And so I think that there are multiple dimensions where these laws could be questionable. So the First Amendment, but then there's also the federalism problem that you're seeing as well.
Well, we're well beyond the end of the scheduled hour, and we've still got most of our attendance. I'm inclined to say we've got a great panel, and to say we're done for the day. But if there are people, there is a very interesting conversation going on in the chat room, and Jorge has raised a pretty broad question that just I think I'll, rather than try to respond to that, Jorge, we can maybe it just tells us we need some more legally focused programs in the future, and we'll get to some of those issues. But if there are other questions that people would like the speakers to respond to right now, we still do have most of our audience in attendance. So before I declare victory here, are there other questions? I don't want to shut off anyone who has a question. According to Ethan, the invitation I sent out was for apparently for 90 minutes, which I originally set because we were transferring from a webinar. So if people want to keep going, that is fine. I'm not trying to send anyone home.
George, I think this has been an incredible session, and thank you, Shaun, for organizing it and for the speakers for sharing their expertise and experience. I'd like to maybe, if we could set up a separate call to think about what actions can this working group take to help support, either in the putting together of tools, resources, links to relevant articles for the citizen science project, so they have a place to start when considering, when faced with these kind of laws.
Yeah, and Leah, what would be the best way for people to respond back to us?
Maybe to email you and I if they have an interest in we could put together maybe a little sub-working group, or maybe this is under Shaun's sub-working group, that we could do some, have a couple of meetings in parallel to our main meeting where we dig into a little bit more.
I think that's right. We also have the Google group, which could certainly be used more than it is. And so if you're a current member of the group, you would be on that Google group. Others should be contacting me or Leah.
Yeah, although I'm very sensitive to the fact that these gentlemen here are in active law cases, right? Where
Right.
sharing anything over an email could be difficult because that email could be spread to the wrong people. So it may be better that we have an offline conversation.
Yeah, I was thinking just in terms of people expressing interest.
Oh, yeah, definitely. Please do. Yeah. And any links to published articles, if people want to share that, or questions that they think we can get lawyers to help answer, etc.
So, this is Jorge. Where can one access the articles and other resources pertaining to this topic, or more broadly speaking about citizen science and issues about citizen science?
Well, I'll address the broad question, and then Shaun, you or the other speakers can talk specifically about your topic. There is a resources page, and in a minute here, I will post that on the sidebar, the Citizen Science Association's website. We have a working group page, and there's a resources link on that. Leah has posted the website for the association. So if you go to that website, look for the Law and Policy Working Group, and then on the working group's homepage, you'll find a tab for resources. So that's a general set of resources. Shaun, specifically for topics discussed today, what do you suggest?
Well, I would say that both Justins have posted links to a couple of really helpful articles that they could look to. So if you look in the chat, there's actually a couple of great articles to get started on thinking about these topics that have been posted there. Yeah, beyond that, I mean, I know we're thinking about trying to gather more materials for the working group, and so we can certainly add more articles on this topic there as well, and the working group resources.
And could we maybe enlist the Justins and Frank to, as we talk about this law review article, maybe contributing a couple of paragraphs or text on each of these topic areas to the well, I shouldn't say law review article, but the state of the law around citizen science.
I think they're saying yes.
I would be happy to help.
Yeah, sure, happy to help too.
Yeah.
Great.
Great. Okay, well, I'm not hearing more questions. There has been a lot of good material in the chat, and I hope there is a way that that is saved. But I think for now, again, this has been a great program. Obviously, it triggered a lot of interest and a lot of good questions. So I think we'll stop here. Again, unless someone wants to raise their hand one more time. Okay, well, if not, thanks for joining us. Great program. Appreciate you guys.
Thank you to our speakers.
Justin, oh, Frank.
Thank you. Justin.
All the 5 or 6 Justins on the call. Okay,
Thank
great.
you all.
Thank you, everyone.
Thank you so much. Good care.
Thank you.
Already, there's a link right there. Bye all.